All right, why don't we get started? Good morning, everyone. My name is Eric Yaffe. I'm a partner at the law firm of Lathrop GPM in the white collar and commercial litigation areas. And I'm here today with Jeff Vigil. Jeff is with Health Partners, has been Deputy General Counsel there for many years and has been overseeing litigation at Health Partners for, I believe, 17 years at this point. Jeff and I will be discussing responding to government subpoenas, and we will focus mostly on documents here, not so much testimonial subpoenas. And we will wait until the end to answer any questions that you might have. Feel free to use the chat button. You'll remain anonymous. We'll be monitoring the chat button throughout, but we'll probably wait until the end because this is a very short presentation to answer any questions that you might have. With that, I'm going to turn it over to Jeff first to discuss from his perspective, from an in-house perspective, how he looks at responding to government subpoenas. And when Jeff has finished, I'll talk a little bit about some other issues that we see as outside counsel. So Jeff, take it away.
Thanks very much, Eric. For us, we found that it's easiest to try to run this as a checklisted process as much as we can so that our approach is at least similar every time. And so a lot of what I'm going to be talking about appears on our checklist, if you will. Also, we found that if we've got a checklist at a variety of people can run the process without having to find that particular person who could be on vacation, et cetera. When we get a subpoena or a CID or any government request for information, particularly of the non-routine sort, a lot of what I'm going to talk about here happens very quickly and simultaneously. So I don't have these in any, I have them in some order, but not necessarily in the order they would actually happen. So the first thing that I'm going to do is take a look and see what kind of request it is. Is it a grand jury subpoena? Is it a civil subpoena? Is it a civil investigative demand? And certainly any one of those may factor into how we respond. One of the most important things for us, being a large organization, is trying to figure out what part of the organization has the requested information, and then who should be our point person within the organization. And then oftentimes we are looking at another law department colleague besides me who can work on this to complement our client's subject matter expertise. Often I'm not the subject matter expert when we get these in. One of the other things that I like to do right from the start is to begin to gather any preliminary questions we may have for the agency. Sometimes that can be extension. Sometimes it can be whether we're a target or a subject or merely a witness. But I like to start aggregating those as quickly as we can so that we have a list either for me or for outside counsel to ask when it's time. As I said, we do try to discern whether the organization is being sought as a witness, a subject, or a target. Obviously, that's not always apparent, often by design. And certainly early on, maybe even before we get outside counsel involved, I will I will ask that question. Sometimes I get a sort of, what do I want to say, a pointed response in less time. And more often I get a softer response that really doesn't answer the question. Certainly, if the information that is being requested is routine or we've seen this kind of request periodically or frequently, it's something that we're less concerned about, and oftentimes we have even more specific processes in place for those. So trying to discern where this falls is important, but not always apparent in my mind. The next thing is, what's the return date of the subpoena? I'm very inclined to ask for an extension for anything that is non-routine. Just knowing for us as a large organization what it can take to get our sort of machinery moving to answer, to find the right people, and to make sure we're doing all the client communication necessary is just going to take longer than often the 2 weeks or so that is the initial deadline for the return. We're also looking at which government agency I get a little bit more concerned if I've got something coming from our state attorney general's office, or if I've got something coming from, say, the fraud division of the Department of Justice. Those things give me a little bit more cause for concern, or would give me more cause for concern if we saw something like that come in. So that's an important factor in making sure my clients are up to date. The next thing we are constantly evaluating is, will a little litigation hold be necessary? Oftentimes, it doesn't seem like one is necessary, particularly at the beginning. It may not seem, or it may not appear, or the government may be telling us that this is is very much routine in their minds. And so oftentimes we will wait to put a litigation hold in place until later. But it's something that we're constantly reevaluating as the matter sort of continues, especially as we begin to get if we begin to get serial requests from the agency. That's something that I'm going to be routinely talking with Eric or our outside counsel about to evaluate that. Next, is the agency requesting electronically stored information, which is almost always the case these days, but frequently, especially in the beginning, we may just be providing paper copies or PDFs of various documents, and that's a little bit easier. But a question for us is, again, can we handle the any production of ESI, or do we need to outsource that? Often we'll work with outside counsel to work with a vendor that they've been using and that they trust, and that makes the process a little bit easier. We as an organization don't typically have a standard or a outside counsel or an ESI vendor, if you will, that we use typically. Most often we can handle those internally. Sort of hearkening back to one of the things I said earlier, who are the custodians of the relevant information? That is, who do we need to contact? And when I think about that, it's really not only our subject matter experts or the leaders, say at the vice president or at the senior vice president level, but who else on their teams may have much more detailed information. And so sort of creating that tree, if you will, that springs from the relevant SVP and then may project down to analysts and coordinators and specialists. And I think for us, often that can be the most daunting part of the process, is just tracking through to see who might have relevant information. And it can be timely, and in my experience, it can be a bit of an archaeological dig for us as well, especially if an agency is requesting things that might go back dozens of years, at least in terms of what we did in the past. So another thing we're thinking about. We're always really evaluating, is this something that we as an in-house counsel should handle, or is it something where we should bring in outside counsel? I will say I have a bias towards using outside counsel, particularly in non-routine matters, because very often they have a process expertise that we don't have, and often have pre-existing relationships with the agency that can make the process easier or certainly more smooth for us. It also doesn't put me in the position of sort of going back and forth with the agency on small matters or large matters. I can really move those to Eric or his team. What we found is gathering information, working with the subject matter experts, making sure that we've done everything perhaps we need to do with a litigation hold can often be a full-time job in itself. And so with that experience, we found it's very good to partner with outside counsel to let them handle drafting of responses, collating of responses, interaction with the agency, et cetera, and allows us to really focus on working with our client and getting the information needed and helping craft the story, if you will, that we're telling. We will be sharing with the agency based on our documents, et cetera. one of the other things that we're constantly evaluating is which stakeholders or clients within our company need to be notified and when. Certainly when we're thinking about that, I'm thinking about the general counsel. I'm thinking about our CEO and her direct reports. We're thinking about the board, et cetera, and making sure that we've at least got that on our list of things to think about. Certainly, we are not typically communicating with those folks right away or suggesting communications with those folks right away, simply because it can take a little bit to get our feet up under us, trying to understand and scope what the agency may be asking for, and whether or not they see us as merely a witness or rather a subject or a target. And so those are things that we're evaluating quickly, but often not communicating about right away. Certainly, we're always aware of reputational risk for our organization. And so another constituent group that I want to make sure that we're involving right away is our communications team. And often that's just a heads up. Sometimes it's a phone call, but working hand in glove with them so that they're not surprised should anything potentially show up in the media is always particularly important. One of the things that I think Eric and I found over time is, I have sort of defaulted to a cooperation with the agency mentality. I've never seen much percentage in trying to go toe to toe with an agency in court about their requests. I don't see a tremendous amount of upside there. But often, I think, or not often, but if you're seeing serial requests from the same agency on the same subject matter, I think assessing your level of cooperation and evaluating that as time goes by is something to think about. I don't know that it's ever really changed our approach on something like this, but I think it's a good question to have in the back of your mind as you're working through this process. The other thing we're routinely thinking about is, do we have insurance coverage? And so we'll work with our risk management team who owns, if you will, our outside insurance coverage, and works with us on whether we need to notify our broker and subsequently our carriers about any potential insurance coverage there. I think that's always something to be thoughtful about, especially if you're coming up on a renewal, for example. It may or may not be the time to share that with your insurance carrier. And so something I'm not trying to say obfuscate with them. I'm just making sure we're thinking about that consideration, if you will. And then the final thing that we're thinking about is the matter that's coming in from the government agency of a type that we need to think about an internal investigation of our own of the issues that appear to be raised by the subpoena. Again, not something that we typically would do, but something that I think is important to have as part of your calculus as you're walking through this process. And with that, Eric, I will turn it back over to you.
Thanks very much, Jeff. So from an outside counsel's perspective, we are getting the subpoena from Jeff of the healthcare organization and immediately taking a very close look at the subpoena to see what's being requested and to see what steps we might need to make to help the client. And the first thing, of course, as Jeff mentioned, is we'll take a look at the return date, because it most likely will be necessary to get an extension of time for the production of those documents that are asked for in the subpoena. The government tends to be very broad in their requests, and usually you'll find that a couple of weeks or however much time they're giving you is not going to be sufficient. One of the things you can do, and one of the things we work with in-house counsel or the organization with, is doing a rolling production of documents. So you might be able to produce some of the documents to the government initially and let the government know that you'll produce other documents at a later date. And sometimes that will satisfy the government and you'll be able to get more time that way than you ordinarily would. It's very important, though, to work with in-house counsel or the person you're talking to within the organization to ensure that all steps to gather the documents are appropriately memorialized. So when we talk to our client, we want to make sure that each and every step is well documented, that they are taking to gather the documents, whether those be paper documents or electronically stored information, because there could come a time later on when you find yourself in court or with a dispute with the government, and you want to make sure that it's not just your word, but you've actually memorialized things and you have a clear understanding and memory of everything you did, who you received the documents from, what the time frame was, what date you received it from the individual within the organization, and so forth, so that you can, in fact, respond appropriately should any kind of dispute or misunderstanding occur. You do want to work with the client also to assess exactly what's going to be produced. As I mentioned, a lot of the requests from government agencies are terribly overbroad, both in terms of time frame and in terms of the scope of information that they're requesting from the organization. So they could be asking for information 10 or 15 years back, and in reality, perhaps the government really only needs a few years of information. And so you could save your client an awful lot of money, an awful lot of time and expense by trying to maybe narrow that time frame. But in addition to the time frame, you also want to take a close look at the scope of the subpoena. All documents concerning a particular subject matter could lead to many gigabytes of information that will be impossible to review. And probably the government doesn't even want all that information. So you want to work with your client, you want to work with the government, to try to narrow the subpoena to the areas of true importance to the government, what they really need to make this process a bit more efficient and effective than it might otherwise be. You also want to work with the client and again with the government as necessary on search terms with respect to electronic discovery that you might be seeking or might need to produce. It's important that you get on the same page with the government on that, because if you use certain search terms, government finds out later on that they don't feel as though you covered everything that was necessary. You're going to find yourself with a double expense, having to potentially go back and redo it, and you really don't want to get into that situation. So you want to make sure that you consider carefully what search terms you want to use, whether you want to use Boolean searches, and go to the government, discuss it with them, and have something that's agreed upon at the end of the day. You can also use predictive coding, which is a more advanced method of searching ESI. But again, you should talk to the government about that first. With predictive coding, oftentimes you can narrow your search and the documents that you're providing even further, and you let the computer do the work. And there are various methods of doing that. But again, you want to make sure that everybody's comfortable with using that approach. But at the end of the day, what's really critically important is that everything you do with respect to your client and with respect to agreements with the government needs to be put in writing, memorialized, and sent to the government. So if you agree on search terms, if you agree on a time frame narrowing of that subpoena, if you agree on narrowing the scope, and you also probably want to agree to some extent on the confidentiality of the documents, you want to put that into a letter or an email, a detailed email or letter to the government to make sure that there's no misunderstanding later on. The last thing you want is for an allegation that you or someone within the organization has obstructed justice, hasn't provided the appropriate documentation, or that there's a contempt proceeding brought against you because of a misunderstanding as to what you were actually producing and what you were supposed to produce. If you enter into an agreement with the government, definitely put it in writing, very important. You also need to know who you're dealing with on the other side in terms of the agency or the prosecutor potentially that you're dealing with. Everyone is human. Everybody's a little bit different. People act differently, and people are going to deal with you differently, obviously, even from the government. So you want to get as much research done on that individual as possible, find out others in the organization or in the law firm who know that person, and get some intel so you know how to address that individual in meetings or in telephone conversations going forward. Because at the end of the day, it's very important that you develop a relationship of trust with the government, whether it's an agency, the FBI, whether it's a prosecutor. You're going to find that it will be much, much easier to deal with the government if they trust you, they trust your organization, and they believe that you're acting ethically and honestly in dealing with them. If they believe you're not, what you're going to find is the government becoming much more aggressive. That's when you see search warrants. That's when you see the government wanting to take, many, many more interviews than they might otherwise take of people within the organization, if they don't trust you. And you're also going to be able to get a lot more information from the government if they feel they can trust you than if they don't. And so it's a lot better to deal with the government with honey than it is with vinegar. I mean, you don't want to have an antagonistic relationship. You want to try to cooperate and let them feel as though this is an organization that is trustworthy and that they can work with. And by the way, at the end of the day, that might lead to a better result for the organization or client, and a lesser sanction, or perhaps a declination against the organization where something otherwise might have been done. But because of that relationship that you develop with them, they were willing to give you a bit more of a break. So it's only helpful to develop a good relationship with the government most of the time. Are there exceptions? Are there instances where you have to be more aggressive, where you might have to move to quash, or you might have to object to the subpoena? Yes, there will be those instances, but those should be far and few between, because as Jeff alluded to, it's going to be hard oftentimes to win those battles with the government. They do have broad authority most of the time to issue subpoenas and to collect documents. So it's better to cooperate as a general rule. You do want to stay ahead of the curve, though, as well. And that is, you want to make sure you understand the matter and the case as best you can. And you want to understand those documents that you're producing to the government. And if you don't, then you do want to tap into, as Jeff again alluded to earlier, experts within your organization who might be able to construe those documents for you, or you might need to talk to witnesses to understand the emails and what their intentions were in those emails. But it's important because you want to make sure that you can deal with the government in an intelligent way, in a position of knowledge, in a position of strength, rather than in a position where you really don't understand and the government has some advantage in that case over the organization. So make sure you do understand the documents, make sure you understand the case well, and get as much information as you can about the government, from the government, about where things are heading. That's going to put you in a better position to respond going forward. Of course, it's also critically important that you protect confidential information, trade secret information, attorney work product, and privileged communications. There is in Rule 45 of the federal rules a clawback provision. Essentially, if something is inadvertently disclosed, you can ask the government not to look at it, to return it to you, but you don't want to rely on that. You don't want to rely on having to make that argument. The government could contend that you waive the privilege. So you want to take a look at the documents. You want to make sure that you know who the attorneys are within the organization, for example, and those attorneys who might have left the organization, but still might have some emails and some responsive documents, so that you don't inadvertently produce those documents. You want to protect them to the greatest extent possible in most instances. Well, again, we're talking mostly about cooperation here. There are reasons, why, again, you might want to, in rare circumstances, object or move to quash. Under the rules, the federal rules, as a general proposition, you can object to the subpoena within 14 days of the issuance of the subpoena, or the return date. I think it's whichever is earlier. But you do need to look at the rules. They really vary from state to state. And I believe with respect to a civil investigative demand or an administrative subpoena, the time frame to object or to move to quash may be a little bit longer, but you really need to make sure you understand those rules. And absolutely, first thing you should be talking to your client about, or the organization needs to think about, is whether you want to move to quash or object because you're going to have a short time frame in which to do that. So you need to upfront make sure you have a good understanding of whether you want to do that or whether you're going to be, as in most instances, in more of a cooperative mode. I think I've covered just about everything that I've wanted to cover. Jeff, I don't know if you have anything else. And if you do have any questions, again, we'd be glad to answer them, but I don't think we see any in the chat function right now. So Jeff, anything further that you might want to comment on?
I would just say, Eric, just listening to sort of going through my comments and then listening to yours, at a real level for us, this is really about a partnership with the law department, with our clients, with outside counsel, and with our stakeholders, and then to some varying extent, the government, to create that trust that Eric was talking about, likely being your best way to be, the best way to be done with these quickly.
Thanks very much. Well, this has been fairly quick. It's 30 minutes. It's really intended just to give you a quick overview of some of the issues that Jeff and I see and some quick takeaways. We appreciate you taking the time this morning. Thanks for taking 30 minutes out of your day. I will give you back the rest of your day and have a good one. Thanks so much.